You have the right to remain silent. You have heard it in 1,000 movies and maybe once in real life. But that sentence was not written by a screenwriter. It comes from a single confession that the Supreme Court of the United States refused to allow, given by a man who won his case at the highest court in the land and still ended up back in prison. This is how 4 sentences rewrote every arrest in America. We treat the warning as a courtesy, a few words an officer mutters while the handcuffs go on. It is not a courtesy. It is a repair. In 1966, the Supreme Court decided that the real problem was not any single officer or any single suspect. The problem was the interrogation room itself, a closed space where steady pressure can turn silence into a confession. So the court built a fix, and it anchored that fix in the Fifth Amendment. The promise that no person can be forced to be a witness against themselves. Over the next 12 minutes, the case that created the warning, the man whose name it carries, and why those few words quietly shape every arrest. It begins in Phoenix, Arizona in 1963. A man named Ernesto Miranda is arrested and taken in for questioning. What happens next is, on the surface, completely ordinary. And that is exactly why it matters. He is placed in a room with police and questioned. And during that questioning, he confesses. He is never told that he does not have to say anything. He is never told that he could have a lawyer sitting beside him. Think about what that room actually is. On one side, trained investigators who do this every day, who control the door, the clock, and the questions. On the other side, one person, alone, who may have no idea where the limits are, whether he can stop, whether he can wait, whether anyone is coming to help. Nothing dramatic has to happen for that imbalance to do its work. The room is quiet, the pressure is patient, and the longer it lasts, the more natural it feels to fill the silence, to explain, to correct, to try to talk your way out. That instinct to keep talking is exactly what the room is built to use. And at the end of it, the most powerful piece of evidence in the entire case is something the suspect produced himself, his own words. A confession feels like proof beyond argument. Who would admit to something they did not do? But the law had started to ask a harder question. Not did he say it, but did he know he had a choice? Because a confession only means what we think it means if the person giving it understood that silence was an option. In that Phoenix interrogation room, no one had told Ernesto Miranda that it was. That confession does not stay in the room. It becomes evidence in court, and on the strength of it, Miranda is convicted. For most defendants, that would be the end of the road. A confession is admitted, a jury hears it, a verdict follows, but his case keeps climbing. The argument on appeal is narrow and sharp, that the confession should never have counted, because Miranda was never told the rights that might have changed whether he spoke at all. It is not a claim that he was tortured or tricked in some movie villain way. It is something quieter and, in a sense, more unsettling, that the ordinary machinery of interrogation can extract words from a person who does not understand the ground he is standing on. And here is the detail most people never learn. Miranda's case did not travel to the Supreme Court alone. By the time it arrived, it had been combined with 3 other cases asking the very same question: Venera vs. New York, Westover vs. United States, and California vs. Stewart. 4 defendants, 4 different interrogation rooms, 1 shared problem. That combination is a signal. When the Supreme Court pulls 4 separate cases together under a single name, it is not trying to fix one man's bad day. It is looking at a pattern, a recurring gap in how the country questions people in custody. The justices were not asking, was this one confession unfair? They were asking, what should have to be true every time? before any of these confessions can be used at all. So the stakes quietly expand. This stops being the story of Ernesto Miranda and becomes a question about every locked interrogation room in the United States, and about the distance between having a right and actually knowing you have it. The court now has to decide whether the Constitution demands that someone close that distance out loud before the questioning begins. On June 13, 1966, the court answers. By a narrow margin, 5 votes to 4, with Chief Justice Earl Warren writing for the majority, it rules that the prosecution may not use statements from a custodial interrogation unless it can show the suspect was first protected by clear safeguards. And then the court does something unusual. It spells the safeguards out. Before questioning, a person in custody must be told 4 things: that they have the right to remain silent, that anything they say can be used against them in court, that they have the right to a lawyer, and that if they cannot afford one, a lawyer will be appointed for them. Those 4 points are the heart of the whole decision. They are not a magic script that has to be read in identical words every time. They are a floor, a minimum the state has to clear before a confession can be trusted in court. Notice where the court grounds all of this. Not in sympathy for suspects, but in the Fifth Amendment, the long-standing rule that the government cannot force you to be a witness against yourself. The warning in the court's reasoning is simply what that promise requires once you are alone in a room with people whose job is to get you to talk. It was not a comfortable decision, and it was not a lopsided one. Justices Harlan and White each dissented, arguing that the majority had reached beyond what the Constitution and earlier cases required, and warning that the new rule would tie the hands of legitimate police work. That disagreement still echoes today. What happens next is the part you already know. You just did not know where it came from. Almost at once, those 4 points harden into a fixed routine. They get printed on cards, taped to station walls, and recited at the moment of arrest until they are nearly automatic. The country starts calling them by the name of the case, the Miranda warning. And this is where the warning reveals what it really is. It is not politeness. It is a small, deliberate transfer of power. For a few seconds, the closed room is forced to open, to admit out loud that the person being questioned has choices: to stay silent, to ask for a lawyer, to make the state prove its case without his help. Power in that room had always belonged to whoever understood the rules. The warning simply hands a piece of that understanding to the one person who usually walks in without it. The warning does not free anyone and does not end interrogation. It just refuses to let the room pretend that the person inside it has no options. Now the twist promised at the start. The warning carries Ernesto Miranda's name, but the ruling did not set him free. The Supreme Court reversed his original conviction, yes, but the state put him on trial a second time, and at that new trial he was convicted again, on other evidence. Sit with that. The most famous name in American criminal procedure belongs to a man who, in the end, was still found guilty. He did not win his freedom. He won something stranger and, for everyone else, far more lasting: a rule. That is the quiet machinery underneath the phrase. The Miranda warning is not really about Ernesto Miranda at all. It is about the next person and the next, the ones who will sit in that same kind of room long after his case is closed. By tying the warning to the Fifth Amendment and forcing it to be said before questioning, the court took a principle that had always existed on paper and made it show up in the one place it had been easiest to ignore: the moment just before someone starts to talk. So a system that had quietly run on the gap between having a right and knowing it now had to close that gap out loud every single time. Step back and the shape of it is clear. We started with a sentence that sounds like set dressing from a crime drama. It is anything but. Strip away the television associations, and what is left is structural. A line drawn around how the state is allowed to gather the most damning evidence of all, your own words. It is a repair the Supreme Court bolted onto the Fifth Amendment in 1966, built out of 4 plain sentences, because the room where confessions are made was tilted against the person inside it. And the man who gave it its name never got the ending you would expect. He won at the highest court in the country and still went back to prison. The warning outlived his case because it was never really his. It was a structural fix written for everyone who would ever be questioned after him. That is the hidden system behind "you have the right to remain silent." Not a courtesy, but a rule that quietly rebalances every arrest in America. If you want to see how a single case can rewire the country's most ordinary moments, this channel is built for exactly that. And the next landmark we open changed who even gets a lawyer in the first place. Until then, now you know why they have to read you your rights.